Supreme Court Justice Sotomayor has refused to put an immediate stop to New York's controversial rifle and shotgun permit requirements. But this legal battle in this case is far from over. Today we're going to talk about how this case, although it was denied emergency review by Justice Sotomayor, might still get emergency review from the larger Supreme Court. So let's talk about what is happening. But real quick before we jump into this video, if you think permits to simply possess rifles and shotguns and other firearms is clearly a violation of the Second Amendment, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like SAF, FBC, and GOA. So if you want to get amazing coffee and support those 2A organizations, I highly recommend you check out Blackout Coffee, and you can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing a new case which is seeking immediate Supreme Court intervention. The case challenges New York's permit requirements that must be met to possess either a rifle or a shotgun within the city. The case we're going to be talking about and breaking down in this video is called Firearm versus the City of New York. This case involves a challenge to the City of New York's application process that essentially requires all the residents of that city to first apply for a permit to be able to possess and acquire rifles and shotguns within the city. One of the major issues with this permit requirement is the fact that it is purely discretionary. That means that the police department there in New York gets to determine who can legally possess these types of firearms. So the law enforcement agency gets to determine who gets to exercise their right to keep and bear arms. And how this happens is the police department there gets to determine who meets the good moral character determination for the application process and who does not. So they get to determine who has the requisite good moral character. This type of permit requirement should be struck down and found invalid and in direct defiance to what the Supreme Court recently said in New York State Rifle and Pistol Association versus Bruin. The plaintiffs argue that under Bruin, the Supreme Court struck down a similar application process that was purely discretionary. The Supreme Court found in Bruin that there was no historical support for may-issue CCW licensing permits. And now the plaintiffs in this case argue that there is no historical support for a may-issue firearms possession permit that is being challenged here in this case. The entire lawsuit and the challenge that now finds its way in the Second Circuit and also in front of the Supreme Court sprung up as a result of that Bruin decision that was issued by the Supreme Court. In Bruin, the Supreme Court struck down New York's may-issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of that Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. In the Bruin case, Justice Thomas, writing for the majority, stated that New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. He went on to state in that opinion that the burden falls on the respondents to show that New York's proper cause requirement is consistent with the nation's historical tradition of firearms regulation. Only if respondents carry that burden can they show that the pre-existing right codified in the Second Amendment and made applicable to the states through the 14th Amendment does not protect petitioners' proposed course of conduct. So that's the backdrop of the Bruin decision, which rejected the use of the proper cause standard to grant or deny concealed carry permits. One of the important things that the Bruin decision did is it struck down this type of discretionary process, this type of discretionary good moral character requirement or proper cause standard that was used to actually grant CCW permits. In this case, the plaintiffs are using the Bruin decision to attack a good moral character requirement that is used to approve or deny permits to simply own or possess rifles and shotguns. This case was brought by plaintiff Joseph Schrower, who challenges the constitutionality of New York's in that city discretionary licensing scheme for the possession of rifles and shotguns. And on review, the district court, the federal court there, granted a permanent injunction in his favor, and they ruled against the provision of the whole licensing scheme that requires individuals to prove their good moral character before being able to simply possess or own rifles and shotguns. That, of course, was a huge win and a huge blow to the state and city of New York. Now, of course, you had a federal district court striking down that good moral character, but the city of New York was not going to let that stand. The city appealed the permanent injunction up to the horrible Second Circuit Court of Appeals. And the Second Circuit Court of Appeals is not pro-2A at all, and they rule against the Second Amendment all the time. Now, also with their appeal, the city of New York sought a stay, which would put the permanent injunction on hold while the case is being appealed. The Second Circuit, of course, ruled in the city of New York's favor and granted that stay. This emergency application that was filed to the Supreme Court is now in direct response to the granting of that stay. What is happening here is the petitioners, the plaintiffs here, Joseph Schrower, is asking for the Supreme Court to remove that emergency stay. They're asking for emergency review of that granting of the stay. They're asking for the removal of that stay, which effectively would allow the good moral character requirement to be removed while the Second Circuit is reviewing this case. So a lot is at stake with this request. What is at stake is people within the city of New York, if the stay is removed, now finally being able to go and possess and purchase rifles and shotguns without having to get that permit. The two main reasons being argued for why the Supreme Court should remove that stay is first that the plaintiffs are unlikely to succeed on the merits of their appeal. The plaintiffs argue that the Second Circuit's reliance on the whole CCIA Antonyuk case, which we've talked about prior, and involves the concealed carry handgun license scheme there that was passed in direct defiance to what the Supreme Court said in Bruin. What is being argued here in this Schrower case is simply that the Second Circuit relying on the Antonyuk granting of injunctions and denial of injunctions, that whole analysis that happened in the Second Circuit is incorrect because these are different cases. The plaintiffs point out that the Antonyuk case is not binding on appeal as it involved a preliminary injunction and not a merits-based determination like is being dealt with here in this case. Also, Antonyuk's analysis is confined to just handguns and does not involve the licensing of long guns, rifles, and shotguns. Antonyuk only deals with handguns. And for the Second Circuit to say that the Antonyuk case deals with all the same issues and closes the issues here in this case is simply incorrect because clearly they are different issues. The plaintiffs also argue that New York has failed to provide any historical analogs to justify the regulation, and that the district court's opinion was constitutionally sound and loyal to the text, history, and tradition analysis that was set out in Heller, McDonald, and now Bruin. And second, they argue that those people in New York are being irreparably harmed. Schrower goes on to argue that the Second Circuit stay has caused substantial and irreparable harm to the applicants who will continue to be harmed, and him himself will be harmed, and other non-disqualified New Yorkers will be harmed because they won't be able to get rifles and shotguns that they might want for self-defense and other purposes. The petitioner contends that the New York City Code is an absolute prohibition on the applicant's ability to possess rifles and shotguns based on a regulation that is clearly contrary to what the Second Amendment says and also what the 14th Amendment says. Now, this application was filed to Justice Sotomayor, who is the justice responsible for reviewing emergency applications and filings that come out of the Second Circuit. And on April 4th, Justice Sotomayor denied that emergency application. Now, I know a lot of people were surprised by that, and usually that's because when an emergency application is filed to the single justice who is responsible for that area, that application is often then simply just submitted to the full court for a vote. And on a full court vote, the entire court will decide what they want to do on that emergency application. But here, Justice Sotomayor denied the application on her own. It was not sent to a full court vote. Now, if you've been following the cases coming out of New York like we've been doing here on this channel, this isn't really that big of a surprise and it's not that out of the norm because recently Justice Sotomayor denied the whole Gazola ammunition restriction and emergency applications that were sent to her. She denied those emergency applications. And then what happened after that denial by Justice Sotomayor, that case, specifically Gazola, was submitted to Justice Thomas on an emergency basis, and then Justice Thomas sent it to a full court vote, and then after the full court vote, the application was denied by the entire court. So although the application here was denied by Justice Sotomayor, I anticipate what will now happen from here is that the application will be refiled to a new justice, probably Justice Alito or Thomas. Again, a full court vote will likely happen, and I'd expect that the court will likely deny intervening in this case despite the fact that it parallels Bruin really well. And that's probably because this issue right now deals with vacating a stay order. It's dealing with vacating a stay order that was issued by the Second Circuit. The Supreme Court often does not like to get involved with stay orders in this kind of in-between order basis. They like final merits decisions, and what's moving forward right now in the Second Circuit is a review of a final merits decision. So this case, Schrower does deal with a final merits decision on striking down the good moral character standard. The Supreme Court will likely just want to wait until the Second Circuit rules on that issue. And ultimately, this case probably at some point will make its way back up to the Supreme Court because it does parallel Bruin really well. We'll be waiting to see what happens. Of course, this has huge implications, not just for the city of New York, the state of New York at large as well, but other states and cities like California, Oregon, Illinois, and others who are putting in place possession permits. There are a lot of states who have passed permits you have to possess firearms. So a decision like this, in this case, will have broad-reaching implications if the Supreme Court steps in on an emergency basis, but we will have to wait and see what happens. So if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.